with the pledge and a moment of silence. Everyone, please stand. Mr. Bazeron, will you lead us in the pledge, please?
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Mr. Bazeron. Being we're live and for the public's information, this is not a consent agenda today, it is a workshop. But I'll go ahead and read the agenda so everyone knows. Our 9 a.m. training is board policy refresher by Attorney Mr. Bob Hammonds. 10:15 regulations and the law for facilities. Robert Gautreaux, Director of Facilities. 11:15 social media best practices. If we don't tell our story, someone else will. Works, Seymour and Gardner. And this training today will adjourn at noon. Before we get into Mr. Hammond's presentation, I'd like to bring up Superintendent Francis Touchette, who has a couple of words for us.
So board members, thank you so much for going through the different sessions yesterday. I know this morning it's going to be somewhat of a, quickly getting in and we'll be out of here, but I wanted to really emphasize the importance of some individuals that I did not mention yesterday, and I purposely did not mention, but I wanted to make sure that you guys were aware moving forward. One is that you know as well as I do, we have done a better job of telling our story as far as communication is concerned. And I'm just going to say this. Are we where we need to be? No. Do we need to get better? Yes. And what I will say to you is that the people that have come on as far as bringing light to the great things that are happening, and it's all due to Tracy Words and Jacob Seymour. These two individuals, I'm going to tell you, behind the scenes are handling things, whether it be proactively or reacting to certain things, they're doing that work. So I want to publicly just thank both of them. The second thing that I really want to highlight, and I'm just going to tell you, if you go to Act 1, Act 1 says that the superintendent hires, the superintendent pretty much the importance of what the superintendent does, and we talked about different principles that we moved around, so people were not in certain jobs, people went to another school or whatever. The superintendent is the one that hires and fires these principals. The superintendent is supposed to evaluate these principals. But I'm going to just say this, in a district that there's 46 different schools, it's hard for the superintendent to go around and evaluate these principals. So what we have done in this system, and I want to explain this to you, is that the 3 people that we have put in positions to evaluate and to supervise principals have principal experience. They have sat in that chair. I can't tell you that, hey, guys, when you sit in a chair, you know what it's all about. That is what's going on. And I'm going to tell you, these chief of schools, what they actually do, Ginger Richard, let me tell you, she actually, last night, 12 o'clock, was the one that actually got a call from the principal. And guess what? She wasn't on the clock, but we're always on the clock. My point is these principals look to Ms. Richard as far as elementary is concerned. Mr. Mouton, being that principal that he was at Broussard Middle, those middle school principals look to Mr. Mouton for guidance. And by all means, we brought in Julie Williams, and I'm going to tell you, she has been a person that has just been, lockstep right there with those high school principals and trying to make sure that it's not about I'm your boss, because I'm going to work alongside of you to get this work done. So I really wanted to highlight these 3 individuals today. I wanted to highlight our communication team, and I just can't say enough about what they all bring to Lafayette Parish. So thanks to you guys. Thanks to you. I truly, and this team cannot do this job without you. So with that being said, I'll turn it over to Mr. Hammond.
Good morning, everyone. Can everybody hear me clearly? I don't usually use microphones, but I'll try one today. The topic that I was asked to talk about dealt with policies, and that pretty much says I can talk about anything I want to talk about. Because there's not much that you can't find some policy that may be applicable to it. You know, and I direct most of these comments at the board members, even though I know we have many other people here today who are very qualified and know and understand a lot of what I'm getting ready to discuss. But you know, board members really have three responsibilities, as you know. The major responsibilities. The first is selecting, contracting with, and evaluating the superintendent. And recently you've done that. And so for this year, that was a check. We can go ahead and move on to number two. Number two is preparing a balanced budget for the operation of the school system. And we heard from Matt yesterday about that process. And so that process has begun. And it's a lengthy process that the board members are ultimately responsible for as your second major area of responsibility. And that just leaves your third. By the way, that budget, by state law, the budget has to be submitted by September the 15th. You always do it in advance of that because your fiscal year starts July 1. So that makes perfect sense to me. But I did want you to be aware of the fact that the statute's still the same, September the 15th. So that leaves major responsibility number three. And that is the adoption of policies for the operation of the school system. You know, you've heard me use the term the holy grail for board members. The holy grail for board members, and I've said it so many times, you ought to be able to pretty much cite the law for me. Cite this revised statute 1781C. That's the one that says the board can adopt any policy it wants so long as it's not inconsistent with law or inconsistent with BESI policy. Now, in preparation for this, I went through your policy manual and actually found that you have a policy BB that says exactly those same words. So you have both a statutory basis for it and a policy basis for it. The ability to come up with the policies that you think are best for your school system. There was some language in another one of your policies, BD, that I thought was pretty interesting. And it says that the board members are responsible for the formulation and adoption of the policies, and that is the primary method by which the board shall exercise its leadership in the operation of the school district, end quote. So by your own policies, you've acknowledged the fact that those policies are important, and they are, according to your policy BD, the most important of the three. And what I wanted to do today is I'm not going to go through your policy manual and tell you about 500 policies. Any of you who have looked at it know it's about the eighth thing now. And we're going to talk about that here in a minute. But what I did want to do this morning was to explain how a policy gets to you for approval. You know, this year we had 792 acts of the legislature. And many of those acts necessitated new policies or amendments to existing policies. So the question is, you know, you guys see them when they are presented to you for approval. But if you've ever had any question as to what happens before they get to you for approval, I think I'd like to allay some of those concerns and tell you how that exactly happens. Most new policy proposals do not come from the staff. They come from the consulting service, Forethought Consulting, that this board has hired many years ago to write policies. Now, Forethought Consulting writes policies for most of the school systems in the state of Louisiana. And they've done it for a long time. And in the interest of full disclosure, the owners, Jim and Noel Prescott, have been lifelong friends of mine. Jim and I played ball together when we were 7 years old. So that means that I've known him for at least 25 years. And by the way, Mr. President,
Yes, sir.
our softball team won the city championship.
Thank you.
Because I couldn't throw it to the other team. Mr. Lashley likes to make fun of the fact that as a high school quarterback, I completed more passes to the other team than I did to my own. And I said, but I did go to the ACT, you know. So here's how we start. Fourth.
Did well, though.
Oh, thank you. I didn't do well in that class. There's always one in every crowd. You just have to be sitting in the front row that makes it even worse. The forethought comes up with a draft of a policy. They send it in. It goes to Desiree as your risk manager. And Desiree's not here, so I'm not saying anything here, you know, to make her feel better. She does a terrific job for you guys. I mean, that risk manager position is one of these behind-the-scenes positions that you don't really see all the things that go on there. But I can tell you, she's very effective and does a really good job. But she looks at it and to see if she sees anything that looks wrong with it or inconsistent with the law with it. It also goes to Jennifer Gardner. I know that because Jennifer calls me about 50 times about this policy or that policy or that policy. So I know that she's studying all of them. I know that some of them go to Dr. Rapolay because I get a call from him from time to time about policies, mainly in the instructional area, but some of the others as well. And I get calls from other staff members about these policies, drafts that have been received by forethought. Now again, you can have any policy you want that's not inconsistent with law or inconsistent with BSEE policy. So the first thing you have to do when you review a draft is to see if it's inconsistent with law or with BSEE policy. That means that you have to be familiar with the statutes that are applicable to that policy. You got to go back and look at the policy to see if it fits with existing statutes, and you have to see if it's consistent with the new act, one of those 792 acts that you're trying to address with that policy change. And then you have to go to the BSEE regulations to see if there's anything in there that's inconsistent with the BSEE regulations. So it's not a snap your finger kind of a deal. You know, there's actually a significant amount of research that's done. So what happens at that point is that, you know, after it's been reviewed by Desiree, by Jennifer, by other staff members, it comes back to me. I do that same review, looking for those things I just described. Then I write a letter to the superintendent saying, I've looked at this pretty carefully. I think it is consistent with law and policy. I think it is available for the board to adopt should it choose to do so. That letter then goes to the superintendent. If there are things in that policy proposal that I don't like, then in the letter I'm going to say, I don't like this. I think this should come out. I think this should be reworded. I'll give you a perfect example. The Pronoun Act that was passed this year, you know, saying certain pronouns that you're supposed to use with individuals. Well, there's a provision in the act that says that if a principal does not use the proper pronoun, that a lawsuit can be filed against the principal, against the school, against the district. And it lists all the things that you can seek in the lawsuit. What kind? You can get injunction, you can get money damages, you can get attorney's fees. That's all contained in the act. Well, when Forethought Consulting came up with their proposed new policy, they just quoted the act, including the remedies in their proposed policy. Now, someone who represents school boards, I couldn't see any reason that you would want to put in one of your policies how you can be sued and what you owe if you get sued. And so that didn't make it to you guys because I cut that out as part of my review. There were other policies in there that were inconsistent with existing policies. And the big one there was the sick leave bank policy. And I know, you know, y'all got 20, 40, 50 policies to adopt. You don't have the time to spend on each of these policies, but the sick leave bank policy was a very interesting one because you already had a sick leave bank. You were required to have it by law. You had it. And basically what it says is that you can donate sick leave days to the bank, and then somebody who needs sick leave days can make an application to the bank to take them out to use them. Now, let me tell you, this is it's a costly situation, because what you're doing then, you're paying for sick leave days that you would not otherwise have had to pay for. So it costs the system money to have this sick leave bank, but you're required by law to have it. So what you did in your bank was you said, okay, we have to have one, so we're going to come up with procedures. And so you had procedures as to who was eligible to donate to the bank, and you had procedures as to who was eligible to draw from the bank, and you had limitations on the number of days that you could do. And all that was put in there so that you could somehow maintain some fiscal integrity, because if you were hit with, 1,000 days of sick leave at one time, that would wipe out your budget. So that was all designed. Now, the act that was passed this past legislative session, 24, says that an individual can donate up to 50% of his accumulated sick leave directly to another person. And so if I have 200 days of accumulated sick leave, because I worked in the system for 25 years, I could give 100 of my 200 to Kate and say, here's 100 days of sick leave. Now the question is, first off, can I give her 100 days? Act says that I can. Your policy says I can't, because the policy limits the number of days that can be given. Similarly, the policy says you can take 10, but I just gave Kate 100. So what happens? Can she use 100? So you have, the point I'm making here is that the act of the legislature was inconsistent with the way that the sick leave bank was being interpreted by the system. And so that was a very troubling area. We spent a lot of time on that one. Can't tell you how many hours I spent with Desiree and Jennifer talking about how would you do that. If I've given 100 days, can she use 100 days? Because if she can't, then what's the purpose for the donation? But again, it's just an example. Sure, absolutely.
How does Bessie create their policy? Is it similar where they're just taking the legislature's policies and their board's voting for them, or do they create internal policies that, despite the legislature, and the legislature just has to, how is their policy? You know what I'm saying?
Yeah, they have the Bessie board. The Bessie board approves policies presented by the staff. And so what the staff does there is the state superintendent will review the statutes, the acts of the legislature, kind of like I do. And then they will come back and make a list of things that are specifically designated to Bessie. And there'll be several acts that says Bessie has the obligation to do this, and to do this, to do this. So then they'll come back, the administration will make a recommendation to the Bessie board. The Bessie board will adopt the policies. The policies are set out for review for a period of time so that anybody can comment on the policies, usually about 45 days. And then after the comment period, then they are, they're adopted by the Bessie board. And then we have to be aware of what those policies are as we move forward with the implementation of any new policies that the board might want to consider.
Do they have a timeline where they have to adopt their policy, or they can just add one anytime throughout the year?
They can add anytime they want during the year when something comes up, but like most school boards, it's usually after the legislative session. Because the legislature gives them obligations just as it gives them to school boards. Not quite as many, but they do give Bessie certain obligations. And one of the things too, when you're looking at the statutes and you're interpreting these acts of the legislature, one of the things that's oftentimes overlooked is you go to the very end and there'll be a funding clause. And if you don't, you read all these things you have to do and you say, my God, this is a lot. This is a lot. This is going to be hard. This is going to be hard. And you get to the last sentence that says, provided funding is made available. And, there have been certain things that for 20 years they've had that same thing, provided funding was made available, and funding never was made available. But, so you need to make sure that you look at that. The other thing you'll need to look at is effective dates. You get an act out of the legislature and you think it's going to be effective immediately or effective August 1 of each year. But there are a number of them that don't kick in until the following year. So we have to mention, I mean, Francis mentioned yesterday about the new evaluation system that kicks in next year. And there are a number of other things that kick in the following year. So you need to look at the effective date, which is another thing that people oftentimes overlook in their review of these policies. But having said all that, I'll then write the letter, I make my recommendations, they go back to the staff. And then the staff looks to see if they agree with my recommendations or they don't. And if they don't, they call me and they say, look, Bob, that one change you made here, we don't like that. We do it differently. That needs to be tweaked. And then we'll go back and tweak it. And after all that discussion is had, then a final draft is prepared, and that is what you guys see. Now, that process takes a considerable period of time, but the reason for this long discussion is because I want the board members to understand that when those policies get to you, they've already been reviewed by at least a dozen people on your staff, including me. And we have written those policies the best way that we know how to write them, consistent with the new law, but consistent with a fashion where they can be effectively implemented in your school system. So I know that you get these, and sometimes you get like 6 or 8 policies all at the same time. And from time to time, you know, I've heard board members say, well, how are we supposed to read and study that many policies for the same meeting? And I'm not saying you shouldn't. I'm just saying that understand that has been done before they get to you. And we're hopeful, as part of that process, I'll say I am hopeful that most of those policy drafts are approved pretty quickly. Because I don't really know that that we could do a much better job of writing them for you.
You represented almost all the school boards in the state of Louisiana. How often did a legislator or a Bessie board member reach out to you and ask about a policy, whether or not it was good or bad, or how it would affect school systems? Did that ever happen?
I'm trying to think.
That answers my question right there. Thank you.
I will tell a story about that. You know, guys, I like to tell stories. Too bad, you stuck with my stories. But they had a situation in EBR where a child turned in a term paper that was clearly not her work. And I remember it vividly because the title of the term paper, and I don't put this out there for anything other than just factual information. Oh, I'm getting the note. I'm not supposed to talk about these kind of stories. But let me just say that a student turned in a term paper, the teacher said it was not your work. The next day, she gets a call from a lawyer threatening to sue her for defamation for accusing the girl of having falsified the term paper. We found out later that she had bought the term paper from a woman who, in Sherwood Forest subdivision, who wrote term papers for students for $35 a pop. And so they wanted to put her out of business. But the problem was there was no statute that prohibits it. You know, we're in a capitalistic system. There was no statute to prevent it. So we decided, EBR decided they want to do something about it. We approached one of their local legislators and asked him if he would sponsor a bill to make it a misdemeanor to knowingly sell term papers. And the reason I tell the story is he asked me, so you need to come down and testify for the legislature on the need for the bill. And I said, certainly, I'll be there. So I walk into the committee room, and he's walking in right beside me. And he said, Bob, I got a problem with your bill. And I said, well, you're the sponsor. If you got a problem, I got a problem. So what's your problem? And he said, well, this bill says that students can't buy term papers. And I said, that's exactly right. Matter of fact, the other way around, people can't sell term papers to the students. And he says, yeah, but the way it's written, this would also apply to LSU football players, and we can't have that. I won't tell the rest of that story. It's a great story. The rest of the story is the bill failed 14-0 in committee. And so, Kate, to answer your question, very, very rarely have we ever been contacted, and I think that they know who we are. our firm gets around the state a little bit. And every now and then we'll have a conversation, but it's certainly not what it should be. Let's put it that way. So that's kind of the policy process. I wanted you to understand the process, but I did also, I forgot the last step of the process, which is important. After you guys approve it, it's not over, because then you gotta train the staff on what the policy calls for. So that means you gotta get some kind of training session for your principals primarily, to let them know the new policies that have been approved by the board. So that's also a part of the policy process, which you have designated to be one of your most important functions.
Could I stop?
Sure, absolutely.
So, one of the things that we implemented, and I want our board to know that if there is a meeting on Wednesday, the following Monday, we always have staff meetings, and the very first thing we do is we go through everything that you guys passed, and we ask the question, how do we communicate this to principals? How do we make sure that these things are done? Because in the past, I felt like there was a disconnect from what you guys did at the table compared to what was needed to be implemented at the school level. So I want you to know that every time there's a board meeting, the following Monday, first thing we open up with is, we go through the agenda and we start going through line by line by letting people know, hey, this is what we need to make sure we communicate, like these projects. If something's being done at Baranco, guess what? That principal needs to know. If something was passed at the table, we want to make sure. So we have really done a good job of implementing that, and it's something that really has kind of helped that communication to the school level.
And really, that staff training is almost a never-ending process, because by the time you get them trained, it's time for another legislative session. And so it's a constant process that needs to be undertaken. One other distinction, though, that I want to make, and again, like I said, I know the Prescotts well and have for a long time, they're friends, but one of the things that we have philosophically different on for a long time is whether or not the policies, your policies, should contain procedures. Now, there are two different principal trains of thought here. One is, my train of thought is, a policy should be a relatively brief statement of intent, a goal, what you would like to see, where you're trying to get to, but not the specifics as to what you do to get to the goal. And that's the difference between a policy and a procedure. Forethought typically incorporates both of them together. And so the goal may be whatever it is, but they put the procedures to get there in the same policy. Now, the disadvantage of doing that is it makes your policy manual about yay thick. The advantage to it that they keep harping on is the fact that your principals and other administrators need to know what the procedures are, and the easiest place for them to find the procedures is attached to the policy. Now, the problem that I have with that is that if you tweak one tiny piece of the procedures after they have been approved by the board as policy, then you got to go back to the board. So I would forecast at your meetings, you would have an agenda that'd be at least as long as your whole current agenda, just with tweaks on administrative regulations to implement the policies that the board has adopted. So my recommendation is always to keep them separate, keep the policy manual more streamlined. If you need, have a procedures manual that's separate and apart from that, but make the procedures within the scope of the superintendent and his staff to promulgate and to change as necessary, to tweak, to make them better, rather than the necessity of bringing them back to the board every time you change any little tiny thing. So it's a difference of opinion as to how you do that. Oftentimes, though, I just wanted to tell you, oftentimes I will take the procedures out. When I get to that level where I'm looking at them, I said, look, this is procedure. This is not policy. And so I'll cut those procedures out, and that's the reason that I do that. But it is important to understand the difference between the two. There were a few policies that I did want to mention specifically here. I went through all of them the last couple of days, and I'm not going to go through all of these, but there's about 5 or 6 of them here that I think you might want to look at. BBBA outlines all of the duties of school board members. And so if somebody ever asked you, well, what do you do as a school board member? Just send them to BBBA, because it's listed in here. Now, there are some interesting provisions that I'm just going to remind you of. No board member, by virtue of his or her office, shall exercise any administrative responsibility with respect to the schools, or as an individual command the services of any employee of the school board. That's in here about 3 or 4 different places. So again, you know, your job is to come up with the policies, the budget, and the superintendent, and then let the staff handle most of the rest of the responsibility. The first responsibility that you have listed for yourself is to familiarize yourself with school law. That's number 1. So, you know, back when I started doing this, you know, 2 or 3 years ago, school law would not have been the first thing in the list, I can tell you. But it's a sign of the times, it's the society that we live in, that it is now your number 1 thing to look at. Number 2, general knowledge, educational philosophies. Number 3, working harmoniously with other board members without trying to dominate the board or neglect your share of the work.
There you go, buddy.
And this, I'm gonna mention number 4 because I'm not pointing any fingers here. To vote and act in the school board meetings impartially for the good of the district. You know, one of the things I hear from time to time in board meetings is that, you know, the schools in my district haven't gotten this, or the schools in my district. And that's not the proper term, because each of you represents every school in the parish. So every school is in your district. You get elected by single-member districts, but you represent the entire parish, and so every school is your school. And so the statement about schools in my district, well, that would be all of them.
Is it the same with Bessie?
Well, Bessie has their zones. The question is whether it would be a state. I think the answer would be yes, because even though they are elected from different zones in the state, and some appointed by the governor, they're supposed to be there to promulgate the policies that are good for public education in the state of Louisiana, and not necessarily those that are good for only a portion of the state of Louisiana.
It sounds like they're just promulgating what the legislature is putting out in the session. So what is the purpose of Bessie? They're not paid, they're appointed. There's no purpose, but they have to raise $500,000 to get his appointment for a free position to basically solidify what the legislature's already done for the school system to adopt. What is the purpose of Bessie?
Well, that's an
Because
excellent.
they're not educators.
That's a good question, and this one's been asked for a long time. Should we abolish this board? You know, and it's gonna be interesting because, you know, our president-elect has said he's gonna abolish the U.S. Office of Education. And so, if he does that, then it wouldn't surprise me a bit that doesn't trickle down to Louisiana and they go after Bessie. But you're right, and the majority of the Bessie members are appointed now by the governor. And so,
And is it just that Klaus needs to be appointed by the governor, just like any other, you know, position that he could appoint you to, like the general board or whatever? I mean, is there any real purpose? Like, if we lost Bessie tomorrow, would there be any loss to the Louisiana? I mean, like,
well, I don't know, losing Bessie, I don't know how that would hurt the school districts. State Department does provide some research and support. I would think that losing the State Department of Education could be a blow to the school
right,
districts.
yeah.
But I really don't see much to be gained by Bessie, and I really never have understood why, as you indicate, that, you know, somebody's gonna seek $500,000 to run for an office that pays nothing.
Right.
But, you know, it is what it is, but, you know, that being the case, I mean, you guys know I'm at that age now where social filter's kind of slipping a little bit.
Well, I kind of doing that.
That's right. Well, who would want to run for an office that all you took was abuse and the maximum pay was $800 a month? Uh-oh, I'm getting the sign again.
No, wait, I get 900.
Okay, that's right.
900.
So, anyway, going back to a couple of your policies, because there's some other things I want to talk about too. And I'm gonna try to move this ahead here. BBBA requires the superintendent to prepare the agenda. Now, that's different in different parishes. And so I get that question from time to time, who prepares the agenda? Well, by your policy, it's done by the superintendent. Also, it says that board members are required to get training in school law, SPED, and other topics, many of which you're getting at this conference. And so again, you're going to be in compliance with BBBC. BBBF allows communication between school board members and staff members. They can contact people directly. You know, if you have a finance question, you call Matt and ask him for something about the business. You know, you have the right by policy to do it so long as you don't circumvent the normal chain of command. And so if you don't want to wear somebody out, you've already got other responsibilities by contacting them. That's BBBF. BBBC deals with your committees. And I know you're aware of this, but you have 5 standing committees. And, you know, those 5 committees by policy are executive committee, for which you can get an extra $50, by the way. Sales tax, blue ribbon committee, finance committee, facilities and long-range planning committee, and the insurance committee. Those are your 5 standing committees. Now, the significance of the standing committee, and this was something I didn't realize y'all had until I reviewed your policies. If you have a meeting of a standing committee, one of those 5 I just described, and you don't have a quorum, but you've got another board member there, you can draft that board member who's sitting there to be a member of the committee for purposes of that meeting for a standing committee, not for any other kind of committee, but for a standing committee, you can draft another board member to sit in.
Happened to you?
So,
You showed up and you got sucked in.
but
I became the chair.
the rest of that story is, though, you can't do it for 2. You know, you can't draft 2 people to sit in to have your quorum. You can only do it for 1. Also, BC gives the president the right to call special meetings and requires and mandates that he shall call a special meeting upon the written request of the superintendent. Or here's one that I didn't know, Anna, upon the written request of the vice president. The vice president has the right to send a letter to the president demanding a special meeting, and he has to call a special meeting.
I'm over here.
Has to be written.
Has to be in writing.
Did you get $50 for
No.
I'll take $50.
that? Yeah, that means.
Or it has to be a letter. It has to be a letter from a majority, or a letter from a majority of the board membership.
I'm abolishing. But we, okay, I have a clarification, sorry, way off. These are our policies.
These are your
That
policies.
we make.
Yes,
So we can change these policies.
absolutely. BCBG requires only a vote of a majority of the members present voting to pass any motion except those that are required by law to require more. So again, that question comes up. How many votes do we have to pass something? Well, it's only a majority of those present and voting, except those cases where it requires more. Like selection of superintendent requires a majority of the total membership of the board. So in your board, that means you'd have to have at least 5 to vote to hire the superintendent, even if you only had 5 there. But for everything else, it's simple majority. Also, the question comes up about reconsideration. I want to reconsider something. And we said we're going to reconsider in accordance with Robert's Rules of Order. Well, if you read Robert's Rules of Order, a motion to reconsider can only be made at the same meeting where you want something reconsidered. So if early on in the meeting you pass something or don't pass something, you can bring it back later in the meeting by making a motion to reconsider. But it is not a motion to reconsider if it's made at a subsequent meeting. So again, because you say we're following Robert's rules, those are Robert's rules. The question then becomes, Well, forget reconsider. Can we just put it back on the agenda for another meeting? And the answer in your parish is yes. You can do that one time in a calendar year. Now, I had an interesting situation back a few months ago where something went to the board in November, and I don't remember what it was, and I know I think it failed, and somebody wanted to have it reconsidered in December. Well, one time in a calendar year, so you could put it back on the agenda for December to consider. Okay, it fails again. Well, now we're into a new calendar year. So can you put it back on the agenda in January?
Yes.
And if it fails in January, you can put it back on the agenda for February. So theoretically, you could look at the same thing for 4 meetings in a row. Now, I'm not suggesting you should do that. I'm just telling you, though, that in the policy that you have, which is a little bit different than a lot of the parishes. Some of the parishes have a 60-day limitation. Y'all have a year. But you can still go around that with 2/3 vote. So if the decide that we think we've got straight what we want to do, you get 2/3 vote, you can add it even if it's more than one at a time in a year. Also, BCBI talks about public participation, and there was one section in it, I mentioned it yesterday to the president. It says, once the school board has begun its deliberation on an agenda item, quote, there shall be no further public comment on that item, end quote. And so my interpretation of that is you don't keep going back to the audience every time there's a new motion. You have a motion on the floor, you go to the public gets to say whatever they want to say within the time limitations given to them by the board. You accept and receive their input, comes back to the board now for you to deliberate. And at that point, that cuts off public debate. And I know one meeting recently that every time there was a new substitute motion made, it went back to the audience. And I'm not saying that that's bad. I mean, if you want to do it that way, you certainly can. But your policy doesn't require it. And I think your policy is within the bounds of law. So I think you should do it that way if you want to do it that way. But I just wanted to mention that fact. BCBI also talks about the other responsibilities of the speakers, staying on task, staying within the timelines, talking about the motion and not other things. And I have to admit that Mr. Latchley is pretty good at making sure they stay. I have some board presidents, I just wonder if they're even awake. Because the motion that's being discussed, it's not, oh, I'm getting the sign again. I mean, it's not even related. It's not even closely related, to the topic that's being voted on. But
They don't have this basin sitting on the side of them either.
no, maybe that's what the deal is. But and anyway, I'm not calling any names because I probably represent them too. But I'm just saying that that for the board president, whomever the board president is, you need to make sure that the comments that are made from the public and from the board are germane to the item that's before the board. If you don't, your meetings are never going to end. Now, there was a couple other things that I was asked by the staff months ago to mention, and I found my notes. You see, I don't have them on the laptop. This is my laptop here. And, Francis said something earlier, he hires and fires all the staff. Well, that's not completely correct. And so one area I'm going to correct him in because it may come up, is that if you're non-renewing the contract of an administrator, like a principal, you're not firing them, you're just saying we're not renewing your contract. That requires that he make a recommendation to the board, and the board has to vote on the recommendation. This is one of the very, very few areas in the personnel that board members have any responsibility. But if you get a letter from him recommending non-renewal of a principal, you'll know now that he is required to do that if in fact he wants to try a new person in that position. So I want to make sure that you understood that process. Now, the process for termination of a principal midstream is totally different. And that process doesn't involve the board at all. So you're not involved in a termination, but you are involved in a non-renewal. And if you say, well, that sounds stupid, well, it is stupid. Because, oh, am I getting the side again?
All right.
Because it was written by some policymakers from California who were brought in to write these policies, and they didn't understand Louisiana law. That's the bottom line. But that's the way that it is, because it says specifically the superintendent shall recommend in those cases.
That's legislation, not policy.
That's legislation, yes.
You say that, and I remember in our first term, Mr. Hidalgo may remember, those did come to us. I do remember that coming to us.
Well, that's one of the few things that you still do in the personnel area. There are a couple others, well, we won't get into today, but that's one, particularly if you're doing a reorg, or if you're doing, anything where you're gonna try new principals, or I pick on principals, could be assistant principals, anybody whose job requires a teaching certificate and who gets paid more than a teacher. Those are the requirements to get the 2 to 4 year contract. If you're in a position that does not require a teaching certificate, then you're not eligible for a 2 to 4 year contract. So that's the key thing that you're always going to look at. Chad, did you have your hand?
Well, I just want to know, if you said it's legislation, is that part of the Pollyanna Code? Is that why California comes in, but we have the Pollyanna Code still in the state of Louisiana?
No, actually, they just didn't understand Louisiana law. 17444 was the statute. If they looked at the statute, they would have known that you were going to have a conflict here. But apparently somebody didn't look at it very carefully. Act 1, we've always talked about Act 1. Y'all have heard me talk about Act 1 for years. 2012 now, so that's been a long time. But it impacted over 50 different statutes. One act with 50 different statutes that would impact. And yet they impacted the termination process, but they didn't impact the non-renewal process. And so we got them both. And if you have them both, you're supposed to interpret them so that they both have some validity. Next thing, and these are jumping around here, but I'm going to try to get finished in my time period because I know you got other important things to hear. The new thing, I say new thing, the most recent thing out there now is public records requests for school board member communication. Now, what they're talking about is your personal cell phones. And so you need to be aware of the fact that if you're transacting in business, if you're talking business with colleagues, and you're doing it via cell phone or via texting or emails, then there's a possibility that you're going to get a request for those. And it's very awkward because then somebody has to go through your cell phone to see if you've turned over everything that would be a business item. And so, again, I just caution you about that. I don't know how board members are supposed to function without the ability to talk to one another. I don't really understand that. But I will tell you, they just had a decision in a case out of St. James Parish 2 weeks ago. You may have seen it in the paper. It didn't deal with the school board, though. It dealt with the city council. And they had some development or something they voted down, and the developer appealed it, and they appealed it on the basis of a violation of the open meetings law because they had, I'm going to get the numbers wrong, maybe 6 council members, and they had 3 of them meet to talk about it, and then they had 3 of them, the other 3 met to talk about it, and they alleged walking quorum. That walking quorum term you've heard me mention before. I actually had the first case in the state of Louisiana where a judge actually, recognized that concept, even though he then ruled against the plaintiff, saying that, you could have a walking quorum, but in this case, you didn't prove that you did. So I won the case, but we lost it with this recognition of a walking quorum, which basically says that if a few of you get together and talk about business, and then a few other of you get ready to talk about the same business, then you count how many were in the 2 meetings and determine that you have a quorum. Well, that would mean that you'd start every meeting by saying, okay, who did you talk to? Who did you talk to? Who did you talk to? Which I think is a very inefficient way to do business, but that's the way that the world is right now. This judge in St. James did rule in favor of the plaintiffs, said it was, in fact, a violation of the open meetings law because there was a walking quorum, even though he never had a quorum present at any one time.
How does that work for committees where there's only 3 people on it?
Well, and that's interesting, because if you got 2 of the 3 and y'all talking business, you got a meeting. If you're talking the business of that committee.
Yeah.
If it's the business of some other committee, that's not gonna be the situation.
Just curious.
Couple other things real quickly, and I'm gonna finish on time, which is really unusual for me. Authorizing reduction in force. If in fact the reorganization results in a reduction in force, then what the board's process is the superintendent comes to the board, says, I think we need a RIF. And the board says yay or nay. And that's it. If you say yay, it goes back to the superintendent and then it's his baby. He goes through the steps, he makes the determination, he looks at the evaluations, it's all done by the administration. But the board starts the process by saying yay or nay as to whether we're going to have a RIF. And that's because we're talking money primarily. It's like a budget item. You know you have budgetary control. So this is related to your budgetary control. So you may be asked, I think sometime in the not too distant future you were asked, am I making this up? But I don't know, Francis, if it was during your term, but maybe it was.
2017.
Yeah, sometime not too long ago, I know that the board actually approved the RIF, but I would say it's been long enough now that we have to go through that process again. Finally, I have a note here talking about basic parliamentary procedures, and the only ones that come up pretty often are that motion to reconsider that we've already talked about, but the other one too is the difference between a substitute motion and a motion to amend. So I'm going to take this opportunity to kind of go over that one more time. Obviously, I'm not doing a very good job explaining it, but look at it this way. A substitute motion means that you're changing the entire substance of what you're trying to do. You know, motion to approve the budget. I make a substitute motion, we don't approve the budget. I mean, a substitute motion is totally different from the original motion. If your motion though is, say, I move that my substitute motion is we approve the budget with these changes. Well, if you vote that down, then you voted down the rest of the budget. And so you don't want to do that. And so in that situation, what you would do is you would make a motion to amend the motion that's on the floor. Because you just want to change a little bit of it. If you just try to change a portion of it and not the overall substance of the motion, it's just a motion to amend. And you can say, I move, we amend to change this line item in such a fashion. You vote on the amendment first, and if the motion passes, then the amendment becomes part of the original motion, and then you go back and vote on the motion as amended. So you need to just say, that seems to come up fairly frequently, and that's the only reason I wanted to mention it. You know, just ask yourself, am I trying to kill the whole motion, or am I just trying to amend the motion?
I want to give Mr. Norman an example. It would be an agenda item that says, we want to recognize that both Acadiana and Karen Crow are elite football program. An amendment would be only Acadiana is the elite football program. That's how you amend the motion.
Okay, gotcha. And you can do that at any point in the meeting, or you gotta wait, is there a certain time you gotta wait to amend the motion?
No, you amend the motion when the motion's on the floor.
We're discussing.
Once it passes, that's it.
And then on an amended motion, you don't have to go back to the public again.
Right, yeah, I got that, we talked about that.
I learned
Or a
that.
substitute motion, which would be that neither program.
Yes.
We have 9 trophies that prove yes, thank you.
So anyway, that's the one that comes up most often. Robert's Rules of Order are so difficult to understand. I don't know why everybody in the world adopts Robert's Rules of Order. There have to be some parliamentary rules that are easier to understand and apply, but everybody just falls back to Robert's rules. But anyway, in closing, I'll just say that, appreciate the opportunity to continue to work with you guys. I think this board's got so many good things going for it, and, hope to be a part of that, as you move forward. We're available. I am in the district, these guys, staff knows, I'm in the district every week, at least one day. So if you want to meet, talk about something, just tell me when, and I'll make myself available to do that.
I have one question about executive session. So
Okay.
the only time that I've ever gone into executive session is for like, some sort of legal issue with our attorneys. Is there any other point in time that we can go into executive session?
Yeah, they have 8 listed reasons, in 4217. You look at the reasons, that's A1 to A8. A1 is to discuss personnel issues, which doesn't happen anymore because y'all are not in the personnel business. But it could be to discuss the superintendent. And, so if you want to go do his evaluation, the way you get in executive session is through personnel issues, which is item number 1, discussion of the character, professional competence of the person. Item number 2 is litigation, which you go into fairly frequently, and you're familiar with that one. That would also include collective bargaining if you had collective bargaining, as far as going into executive session. And you got, one of the ones that's not used ever is to investigate allegations of misconduct. And I think that's one that board members need to recall, because we had a case not too long ago where money was missing from a vault at school. And the superintendent wanted to bring it to the attention of the board that the money was missing, but he didn't know for sure who took it. And so it's not like you couldn't use number 1 because you don't know what professional competence you're discussing. You don't know who it is. So there is a number 4 that will allow you to go in to discuss the investigation that's ongoing, so he can bring that matter to your attention. And of course, the other one that comes into play from time to time is number 7, which is dealing with student issues. That's going to be your expulsion appeals. Anytime a parent wants to bring a student issue to the attention of the board, there is a number 7. Number 8 is the omnibus provision that says anything else provided by law. So it used to be back in the day for a tenure hearing where you had the board conducted a hearing. That gave the board the ability to go into executive session and conduct a tenure hearing. You don't do those anymore, so that's not one that's used as often as it used to be used. But there are at least 8 listed grounds for which you can go in. The only one that requires that you put it in the agenda is litigation. If you're going to go in to discuss litigation, the agenda, on the face of the agenda, it has to name the case and the number and the court. All the others do not have that requirement. So that's the other distinction that you have with the open meetings law.
What would be the motion, just to go into executive session to discuss issues?
If
And you don't
it-
even have to say which.
Well, I prefer that you say which one you're going in under, because it needs to be reflected in the minutes. Also needs to be reflected in the minutes how each board member voted on the executive session, because there are sanctions available if you violate the open meetings law. So one of the things that y'all don't do a really good job at, we do it, I think we figured out, is you really should have a vote. There's always a motion made to go in executive session, there's a second, and everybody stands up and walks to the committee room without necessarily taking the vote to do it. But we need to make sure we take that vote, Mr. President, because it needs to be reflected in the minutes.
Well, we do, all those in favor say aye, all those in favor say nay.
And that's fine.
That's the way.
Yeah, and then we get, Christie and her team to make sure that it's reflected in the minutes, and then we're good to go in case somebody has a challenge.
And it does not have to be unanimous, right?
Does, under certain circumstances, it's gonna require a 2/3 vote to cut the public out. But it's gonna be something that, again, you can't take any action back there, and that's something that a lot of people don't understand. You can discuss, but you can't do anything back there. You have to come out in public to take any action.
All right, Mr. Hammond, we'll let everybody take a 15-minute break and then we'll get back at it. The one thing I think, as you're walking away, maybe remind them, when you make a motion, you do have to explain why, right?
To recuse yourself?
No,
No, now.
when you make the motion, you have to say why.
No, you have to make a if you're gonna recuse yourself, you're supposed to state a reason why you're recusing yourself.
To pull an agenda item, that's it.
Pull an agenda item, yes, you do need to say why.
Thank you, Ms. Gidry.
Any other questions?
When do you say that? Like, when you pull it and then the motion comes up, you have to say why you pulled it first and then you make the motion?
When you pull it. Yeah, whenever you pull the item, you're supposed to say why you want to have
You
it.
say pulling it for discussion.
That's right. More information.
For your reason.
Well, you can. I would get into that. There's no more takes away from the board member.
But I just want to know why.
Still asking.